Expectation damages are a contractual remedy where a court will require a breaching party to pay money to an injured party because of a breach of contract. Hi, I'm Professor Seth Orenberg, and today we're going to discuss expectation damages and how to calculate them. It's a bit tricky, but I think this video will help you sort it all out. So let's go ahead and get started. Whenever a contract is breached, whenever a contractual promise is not fulfilled, or in technical terms, whenever an obligor breaches its contractual obligation, the obligee, the person to whom the obligation was owed, is entitled to a remedy at law. But which remedy? That's one of the first things to figure out. So let's take a look at the remedies in general, and then we'll zoom in on expectation damages, which is one of the core remedies in contract law. This chart shows all of the remedies that are related to contract law, and they come in three basic categories. The first category is money damages, and that's when a court will require a breaching party to pay, you guessed it, money to a party who is injured by that breach. This requires there to be a contract, because only a contract can be breached, and it requires the party who is injured to be a non-breaching party, to have honored its contractual obligations. So they are somewhat limited, but there are many cases, of course, where a contract has been breached and money damages would be awarded. The most common money damage is expectation damages, but there's also reliance damages, nominal damages, punitive damages, and liquidated damages. Next up are the equitable remedies, and these are somewhat exceptional. Specific performance and negative injunction are where a court will actually require a party to do what it promised to do, or not to do what it promised to refrain from doing under a contract. We still need to have some type of contract or quasi-contractual obligation in order for such an obligation to be enforced. But this is different from money damages because the party actually has to do what it promised to do, not just pay money for its failure to do so. Third are the restitutionary remedies in blue. And these remedies of monetary restitution and specific restitution are more closely related to the doctrine of unjust enrichment, which transcends contract law and touches on many areas of law. The concept in restitution is that sometimes a party pays some money or gives up some object unjustly. They are either tricked or there is some other reason why it is inequitable that that transfer occurred. And the court effectively will rescind that transfer, either by requiring a disgorgement or repayment of the money or giving the thing back. These are not contract remedies per se, but in many cases where there is no effective contract remedy, because, for example, there's no enforceable contract, a restitutionary remedy may be available so that the party can still recover. So there you have all of the remedies that are related to contractual law. Let's zoom in on money damages. Money damages are an award of money that a court will require a breaching party to pay to an injured party who has not breached the contractual agreement. This can only be awarded when there is an enforceable contract at law and a party failed to perform its obligations thereunder. There are 5 types of money damages, and the first and perhaps most important, certainly the most common, is expectation damages. Expectation damages seek to put the injured party in the position it would have been in if the contract was fully performed, and it awards the party the difference between what it expected from the contractual bargain and what it actually received from its counterparty. Reliance damages are a bit different. They seek to unwind the transaction and put the party in the position it was in previous to the contract having ever been formed, returning any amounts invested or spent in reliance that the contractual promise would be honored. Nominal damages are just a token amount, something small like $1 or $10 that a court will require in order to show there has been a breach and a violation of a contractual obligation, but one that didn't result in any real injury or harm. Punitive damages are not really a contract concept. In general, punitive damages are not allowed. But when a contractual breach is so officious that it's also a tort, like fraud or misrepresentation, those tort damages may stack on top of the contractual damages, and those additional tort damages, in addition to the contractual damages, are known as punitive damages. And again, they're only available where there has been a tort in addition to the contractual breach. Finally, there are liquidated damages, which is when a party has agreed to pay a certain amount in the event of a breach, and the parties have between each other preordained or prescribed what shall happen if a breach were to occur. For example, in a lease for a year, there might be a provision that if the tenant breaks the lease prior to the end, the tenant must pay 2 months' rent. That would be an example of a liquidated damages provision, and courts will usually honor that and have the liquidated damages be the measure of damages, so long as they are not so large as to be disproportionate with the actual loss. Let's look at expectation damages in some greater detail. Expectation damages are the most common ordinary and general damages awarded when a contract is breached as a matter of law. And expectation damages are designed to put the injured party in the position it would have been in had the breaching party fully performed its obligations. In other words, it's meant to give the party what it expected as the value of the contract. Expectation damages have three additive components, which all combine to show the total amount of the loss that needs to be awarded. The first is direct loss, which is the amount of difference between the value received and the value expected under the contract. But in addition to that, there are incidental losses, which directly flow from the breach. They weren't part of what was expected, but they are costs or losses that occur because the breach occurred. And another concept, consequential loss, very similar to incidental loss, but somewhat more attenuated consequences that flowed proximately and foreseeably from the breach. Direct loss can be measured in three different ways. It can generally be measured by loss in value, which again is the difference between what the party expected to receive from the contract and what the party actually received under the contract. But sometimes loss in value is not the best measure, or it's difficult to estimate. So, cost of completing performance is another way to measure the direct loss under a contract and include that in the calculation for expectation damages. Finally, when a party sells in volume, such as a car dealership that sells many cars over a period of time and not just one item, the breach by a buyer can cause a loss in volume of sales. And then we apply the loss in volume method of calculating direct loss in order to determine expectation damages. There are multiple ways that different treatises, texts, hornbooks, etc. talk about how to calculate expectation damages. But really, they all amount literally to the same thing. There's a formula, and we're really all talking about the same thing. So I'm going to share with you a few different ways to formulate or think through calculating expectation damages, and I hope you'll see the symmetry between these different explanations. The simplest way to think about expectation damages is that we add the direct loss, which is the difference between what the party bargained for and expected and what the party received. We add to that indirect loss, which are losses that are incidental or consequential to the breach that flow from the breach. They're approximately caused by the breach and are reasonably foreseeable by the breaching party, minus any cost avoided. If the contract is terminated early, the injured party might have avoided certain costs, also sometimes called losses, by not having to perform any more of its obligations, such as a buyer who had only paid part of the purchase price has avoided the cost of paying the remainder of the purchase price. The Restatement Second of Contracts in Section 347 formulates this a bit differently, and it talks about the measure of expectation damages as including the loss in value to the injured party due to the other party, the breaching party's failure or deficiency in performance, plus any other loss, including incidental loss or consequential loss caused by that same breach, less any cost or other loss that the injured party has avoided by not having to perform. In addition to this formulation, I have seen many textbooks talk about direct loss plus other loss minus cost avoided minus other loss avoided. How can we square these different formulas? Well, direct loss is one way to express loss in value, or another way to say that is loss in value is one measure of direct loss. Other ways to measure direct loss may include loss in volume and cost of completing performance. Other loss refers to indirect loss. In other words, other loss is synonymous with indirect loss, and indirect loss and other loss, being synonyms, both capture the concepts of incidental loss and consequential loss. Formulations that talk about cost avoided usually, and also talk about other loss avoided, usually intend cost avoided to mean any amounts not directly paid. So if there was a breach before the buyer paid for the entire shipment, or if there was a breach by the buyer or repudiation by the buyer before the seller completed all of its production, those are direct costs avoided. And that's meant to parallel the concept of direct loss. Cost avoided is often phrased alternatively as direct loss avoided. And then there is other loss avoided, which means other losses that would have flowed from performance. But really, I find that to be a somewhat unhelpful distinction. And again, I think it's easiest and I think best to think about this as simply direct loss plus indirect loss minus cost and loss avoided, and that being your basic formula. That said, I hope that helped you understand better why some other treatises or books use slightly different words. It means the same thing. Moreover, loss and damages are another synonym. So sometimes you'll see it phrased direct damages as opposed to direct loss. It's the same thing. We're looking for the same thing. The direct is the amount, the delta, the difference between what was expected and what was received. Indirect is incidental and consequential losses, or indirect damages, or incidental damages and consequential damages. All means the same thing. Those are the other damages, other losses, other costs, other harms that result proximately and foreseeably by the breach. And then cost avoided, loss avoided, other loss avoided. Those are the expenses that the injured party did not have to incur because the breach did occur. There is one more concept that is worth mentioning, which is the concept of lost sales volume. And the restatement does directly address this in one of its comments. If a party is a volume seller, instead of measuring the direct loss of the one unit that wasn't sold because of a breach, it may make more sense to measure the lost sales volume of the inability to sell one more unit. And that concept is another measure of direct loss. As opposed to loss in value, we measure lost sales volume. Direct loss is best and most often measured by loss in value, which is the difference between what the party bargained for or expected to receive and what the party actually received under the agreement as it unfolded, which effectively is the difference between what the party expected and what the party received, hence expectation damages. So let's calculate loss in value. Calculating loss in value is another formula important to remember in understanding contractual damages. The concept of loss in value is relatively simple. We look at the value that was expected and subtract the value that was received to arrive at the difference or diminution or loss in the value. It's the difference between what was expected or promised under the contract, what was bargained for, and what actually occurred. That's the extent of the direct loss in value. In the case of a seller, it may be simpler to think of this, or easier to think of this, in terms of the price that the seller has not yet received from the buyer, because it's the buyer who pays the price. So first, that's what the seller expects. The seller expects the buyer to pay the price. So that's the value expected by the seller, the price under the contract that the buyer should pay. And we would subtract from that the amount of money the seller did not spend, the amount of cost the seller avoided, because that would show the difference between what the seller expected to spend and what the seller actually spent. If the seller spent less than expected, that should reduce the amount of damages the seller receives because the seller did not actually incur those expected costs. So price unpaid minus cost avoided equals seller's loss in value. Moving to the buyer's side of the equation, the buyer might prove the loss in value by having someone else complete the work. So if the buyer was paying for a painting service to paint 5 rooms in a house, and the painting service only painted 1 room, how do we measure the value that was lost, the difference between the value expected and the value received? One way to measure that value very clearly is by hiring someone else to complete the work. So if it costs $500 to paint the other 4 rooms, that's the cost of substitute performance. That's a neat, clean way of showing the delta between what the buyer expected and received from that first painter who breached. That's how much the buyer had to pay to make up the difference with someone else performing. And if the buyer, again, didn't have any costs or had a reduction in the amount of costs that they incurred, that should be reduced from the amount of expectation damages because the buyer expected to spend those costs. Maybe the buyer expected to pay for the paint, and as a result of the painter not showing up, it never had to buy the paint. Since the buyer expected to spend that money, that amount of money the buyer didn't have to spend should be reduced from the expectation damages. The seller shouldn't have to pay for that twice effectively. So those are some ways to think about calculating loss in value. It's important to be flexible about this because every contract will have slightly different economics. But if you remember that the goal is to think about the value that was expected and subtract the value that was received, arriving at the difference in value, you can determine the loss in value under direct damages and expectation damages to a contract. There are several alternatives to loss in value when measuring the direct loss component of expectation damages. One is the diminution of market price. It may be difficult to determine how much value was lost because the buyer chooses not to or is unable to substitute the seller's performance. But if the breach can be shown by the amount of the breach can be shown by some reduction in market value, that is a way to show how much value was lost. Another way to show how much value was lost is the cost to complete the performance. So if it's difficult to determine the delta, the difference between what was expected and what was actually provided under a contract, one way to show that difference is to get to the expectation to complete the performance. However, courts will not award the cost of completing performance when it's disproportionate to the loss in value itself. There's a concept called efficient breach, and we don't have time for that here, but it's worth a Google search. The idea is that contracts are economic instruments that are designed to increase social welfare. And sometimes it's a good idea for parties to breach. It's good for society for a party to breach, because it wouldn't add value to complete the performance. When completing the performance actually reduces social welfare and social value because it's so disproportionate to the actual loss in value caused by the breach, courts will not award the reasonable cost of completing performance. Well, in those cases, that cost won't be reasonable, and therefore courts won't award it. The second component of expectation damages, once you've arrived at the amount for the direct loss component through one of those 3 measures of direct loss, again, loss in value being the most common measure of direct loss, is incidental loss. So let's calculate incidental loss and add that to our expectation damages calculation. Incidental losses are losses reasonably associated with or related to actual damages. They're sort of one step away from actual damages. There are many examples of potential incidental losses, but they all have to be caused by and related to and associated with the breach itself and the harm itself. Here are two examples that may give you some idea of how to spot these incidental damages. A seller's commercially reasonable expenses incurred in stopping delivery or in transporting and caring for goods after a buyer's breach are incidental losses of that seller. And a buyer's expenses reasonably incurred in caring for goods after a seller's breach is also an incidental loss. The third element in expectation damages are consequential losses. Consequential losses are losses that do not directly come from the breach. They weren't part of what the parties expected, but they reasonably flow from the injurious act. This is a more nebulous concept, and I recommend you read the case of Hadley versus Baxendale. That's the case about the mill whose broken crankshaft was sent back to a factory and the shipper was late in that delivery, causing the mill to be out of operation for a period of time. And the question was whether the lost profits while the mill was closed was consequential loss. It's important to read that case to understand how courts will think about consequential losses. It is a rather elusive, slippery concept because it has to do with reasonable foreseeability and proximate causation. Consequential losses are losses that do not flow directly and immediately from an injurious act, but result indirectly from that act. Well, lots of things can arise indirectly because of some action. They say that if a butterfly flaps its wings in Shanghai, you might have a tornado in Oklahoma. So actually determining cause and effect is very challenging. For this reason, courts limit the extent of consequential losses to those that are reasonably foreseeable by the breaching party, things the breaching party knew or should have known might occur, and are proximately caused by the breach. Proximate cause being a concept used heavily in tort law, not as often in contract law, but you find it here. In conclusion, expectation damages are calculated by adding direct loss, which is usually loss in value, but could be the cost of completing performance or loss in volume, plus indirect losses, which include incidental loss and consequential loss. And then we subtract any cost or other loss avoided by the injured party in order to put the injured party in the position it would have been in had the contract been fully performed. For more on damages, check out my other videos on money damages and remedies in general. The other money damages we'll discuss, in addition to this talk on expectation damages, are reliance damages, which put the party in the position it would have been in had the contract never been formed, nominal damages, which recognize there was a breach but only require some token amount to be paid because there was no injury per se from that breach, punitive damages, which are really a tort concept when a breach is so officious as to merit a tort in addition to contract damages, and liquidated damages, which are when the parties prescribe a formula in advance as to what will happen if there's a breach. I hope that helps you understand contract remedies and money damages in particular. Thanks for watching.